My
My lord's kind leave to mention one matter.
Yes,
My lord,
please.
my senior is here, my lord.
Lordship, may I have your kind leave to mention item number 32 of this, my lord. Kindly remember that on 23rd of July matter was taken up, but wrong file was placed before your lordship. That is
Yes,
the matter.
it went
So
down.
it is very important issue is involved because that appeal has been dismissed due to the delay.
What do you want? Upgradation.
Upgradation.
Let us see how we proceed today. Based on that, we'll do.
She mentioning for correction appellate side.
Hmm.
One just the writ petition number has been incorrectly mentioned into place.
Show it in days list.
lord, maybe
Who appeared for the response?
Lordship, state. Tanay sir and Saptak sir was there that day. Lordship, only this WPO that has been given, it will be WPA that time.
Yes,
My lord, may I crave leave to mention a matter? My lord, this matter is below the tax effect of 2 crores, my lord, for listing.
My lord, may I be permitted to mention one matter, my lord. Pursuant to the order dated 16th May 2024, passed by your lordships, my lord, there is a stay which the appellants are enjoying, my lord, but the problem is that the state of Mizoram is unable to utilize the land for construction of the building for the benefit of the public. The public
it's
interest.
a group 9 matter.
Group 9 matter, my lord.
Group 9, we don't.
My lord,
have-
you have a notification irrespective of any year, my lord.
No.
Irrespective of any year, my lord, is a notification, my lord. Any matter irrespective of any year. Appellate side, my lord.
Appellate side.
My lord, any matter irrespective of any year, any.
No. That is a general power given to the court number 1, Chief Justice.
So, my lord, if lordship is, it's lordship's order only, my lord. If lordship can take up the hearing, my lord.
Mentioned before the appropriate division bench, which has got determination for group 9. In
Well,
case they release the matter, then it will come to you. Okay.
Lord, if lordship can kindly, my lord, since it's a notification, if lordship, it's your order only, my lord. If you can take
That's
it.
not the way to interpret the notification.
Lord's kind leave to mention this matter.
You have not read the full sentence.
It is also in the original.
Yes. Yes.
Lord's kind leave to mention this matter, my lord. I have been working as a majdoor with the ECL. Now I am 100% paralyzed due to some motor neuron disease. My lord, the medical board of ECL says that I can still work, whereas the certificate of disability issued by the government of West Bengal says I'm 100% disabled and I'm unable to work. Now my son is denied of compassionate appointment because of this, because of the dichotomy. My lord, kindly hears this matter out. I'm due to retire on this September. My lord, anytime next week.
It's a group 6, it's a different division bench. Please check the determination.
My lord, then I'm.
My lord, kindly allow me to mention this matter. My lord, this matter is below tax effect of 2
Below tax.
Kindly permit to.
Anjan, Wednesday you list. Both the matter. Yes.
Original side daily list, item number 1.
Appear for the respondent, my lord.
There's no paper.
No paper, my lord.
We can, what to do? Or we'll say dismiss for default. None appears for the appellant. So also appears for the respondent department. Appeal dismissed for non-prosecution. Next, we have mentioned none appears for the appellant. Though a warning list was published on 4th July 2025. Thus it appears that the appellant is not interested in prosecuting the matter. Hence appeal stands dismissed for non-prosecution. It is an admitted matter. Huh? So the substantial questions of law suggested by the appellant assessee are left open.
Item number 2.
I am for the respondent, my lord. The appellant respondent has gone into Corvidat Samaran scheme, my lord. That has now been disposed of. Ajay.
Please take note. This appeal, sir, this appeal has been filed by the revenue under section 260 capital of Income Tax Act 19. challenging the order dated 31/8/2009 passed by the Income Tax Appellate Tribunal, A Bench, Kolkata, in ITA number 1
speculative losses of
in ITA for the assessment year 2005 and ITA number 1190/K1/2008 for the assessment year 2004-5.
with the business income. 43B.
General advocate appearing for the respondent that the assessee has availed the benefit of the direct tax Vivad Se Vishwas scheme and the necessary form and the appropriate forms have been issued in favor of the respondent assessee. In the light of the same, the appeal stands disposed of on the ground that the respondent assessee has availed the benefit of the scheme and the substantial questions of law raised by the revenue are left open.
Form 5 has been also issued, my lord.
That we are recorded. The requisite forms, more particularly Form 5. Next.
Item number 3.
I am for the appellant, my lord. That the assessee had claimed future and option loss of 51 crores 71 lakhs. And profit from business expenses hit off because of this loss.
Section 73 এটা
তুই কর
না
আমি
তুমি কর আমি দেখি
কর।
ঠিক নেই তো পড়া নেই তোমাকে তো ব্রিফ আছে
করার দরকার
এখন জজমেন্ট এটা দাও ওকে
দুটো জজকে দেওয়ার মতো
আচ্ছা
না ঠিক আছে
সার্ভিস করতে বলেছিল
কিন্তু একটা তো অর্ডার সেম অর্ডার
হ্যাঁ
সে মানে দুটো অ্যাসেসমেন্টই অ্যাসেস
তাই তো হয়েছে এপিতে দুটো থাকলে একটা ফি দেবে না দুটো আর একই দিনে দুটো আলাদা অর্ডার হয় একটাই ফি দেবে বলে দিচ্ছি অ্যানালোগাস করে দেবে কি আর হবে এটা রসিদ সার্ভিস করতে বলেছিল করেছে কিন্তু কাগজটা এখনো আমাদের হাতে আসেনি মানে রিটার্ন হয়ে এসেছিল জিনিসটা কিন্তু টাইম ট্রানসাকশন ম্যানেজমেন্ট মানে টাইম লাগে একটা
What is this future and option? Then? The first time I am coming with us.
These are not to curb that speculation activity in the stock market. They're based on the underlying shares, but they are not. It does not amount to trading in shares and securities. They are derivatives. So they on the what is going to the future price, or whether it will fall, it will go up. Based on that, the contract is made. That if the price goes up, then this will be the result. If the price falls,
So even if the price goes up, there will be a cap because of this agreement.
yes. So therefore, I had read up on this some time ago, but essence of it is that there are prices fixed, that as to what the prices are going to be in future. Based on that, these contracts are made.
So there is actually no trading of or sale or purchase of shares.
No. There's no the question which the revenue has posed has been considered by our court in a matter which is reported.
So it's covered by a decision.
Yes. But questions B and C in the reported decision.
আমাদের বোতল মতো ধরে নেবে এক্ষুনি 5 মিনিট গ্রাফাইটটা মনে হয় সোমেনের আছে চলতে পারে এখানে ওল্ড ম্যাটারের মতো বলছি তারপরে তো বোতল মতো রিয়েলি বলছি গ্রাফাইটটাও চলতে পারে 8 নম্বর এটা আমাদের 9-10
ডি এখানে আছে।
অন্য জায়গায় যাবে নাকি
5-এ আছে না,
5-এ 3 আছে 7 তো হয়ে
3
গেছে
আছে, 7 আছে।
ওটা হয়নি 3টা
আমি কি চলে
আচ্ছা জুনিয়রকে বলে দিই আমি তোমার কাছে আছি ইউনিয়ন অফ ইন্ডিয়া বিদ্রোহ করবে 3টা
So they distinguished the Delhi High Court decision.
And not in the statute itself, section 43(5), it has been extracted.
It is extracted.
Lord. And if my lords may see that subsection 5 of section 43. But the not A is in respect of the proviso. Lord.
Consider.
So if there is no actual delivery, no, then it's a speculative transaction. And then what the proviso excludes certain transactions. So A is in respect of raw materials. B is in respect of stocks and shares. C again is in respect of relating to shares. D is where these derivatives were brought in by the statutory amendment came by the Finance Act 2005 with effect from assessment year 6-7. So they were treated as not speculative, although there's no delivery involved.
So which is this assessment here?
Ours is 8-9.
8-9. So it will fall under subsection 5D.
Yes, ma'am. Clause D and the revenue eligible transaction is also defined in the explanation, and
So it cannot be brought under the definition of speculative transaction.
yes, by definition it is excluded. Then was section 73.
That's what the revenue relied on.
Yes, that dealt with a transaction in shares. Trading in shares.
আমি এখনই এই মামলাটা তোমার থেকে ডিসটিংগুইশ করে দিই অ্যাডমিটটা করে দিতে পারতাম
The explanation that has undergone amendment. If my lords are pleased to have a look at the explanation in the reported judgment, Because not at under paragraph 5, where any part of the business of a company other than a company whose gross total income consists mainly of income which is chargeable under the heads interest on securities, income from house property, capital gains, and income from other sources, or a company the principal business of which is the business of trading in shares or banking. In fact, this is also the amended portion, or the granting of loans and advances consists in the purchase and sale of shares of other companies. Such other company shall, for the purpose of this section, be deemed to be carrying on speculation business to the extent to which the business consists of the purchase and sale of such shares.
So the catchwords are purchase and sale.
Of shares. So here it is, although it does not fall under 43.5 because there's actual delivery, but not to the extent it is purchase and sale of shares, it is deemed speculative business for the purpose of section 73. So our court would also consider this aspect that these are not shares, derivatives are not shares, so they will not come under this explanation.
What is? It's covered by this decision. Please come.
Though I would have liked to distinguish this, but perhaps.
Coordinate bench. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket TI is directed against the order dated 4/5/2011 passed by the Income Tax Appellate Tribunal A bench Calcutta number 1033/KOL/2011 for the assessment year 2008-9. The revenue has raised the following substantial questions of law for consideration. Page 7, only one question. We have heard so and so. The substantial question of law raised by the revenue in the instant case was considered by the Honorable Division Bench of this Court in the case of Asian Financial Services Limited versus Commissioner of Income Tax 3, Kolkata, 2016-70 taxman.com 9 within bracket Calcutta. In the said appeal filed by the assessee, identical question of law was raised in questions of law B and C in paragraph 1 of the said reported decision. The Honorable Division Bench allowed the assessee's appeal. Before us, the learned senior standing counsel placed reliance on section 73 of the Act, stating that the said provision is a specific provision, whereas what was relied on by the assessee and accepted by the appellate authority, namely section 43 within bracket 5, is a general provision. And submitted that a company dealing in purchase and sale of shares, among others, which does not come within the exceptions carved out in the explanation itself, is hit by the mischief of the offer of the explanation under section 73 within bracket 4 of the Act. Further, it is submitted by the learned senior standing counsel that when the business consisting of purchase and sale of shares of other companies amounts to speculation business, can it be said that can it be said that the business in derivatives, which depend upon the value of underlying shares, is anything other than speculative business? The Honorable Division Bench did not accept this. Identical submissions were made before the Honorable Division Bench in Asian Financial Services Limited, and the argument of the revenue was rejected. At this juncture, it will be beneficial to refer to the relevant paragraphs of the said judgment. Paragraph E2. 13. 1 3. Thus, applying the law laid down in the above decision, it has to be held that the loss incurred on account of derivatives would be deemed business loss under the proviso to section 43 within bracket 5 and not speculation loss, and hence explanation to section 73 would not be applied, semicolon, as such loss, as such, semicolon, as such, loss would be set off against income from business. Thus, following the above decision, the appeal filed by the revenue is dismissed and the substantial question of law is answered against the. Yes.
Item number 4.
But I have been instructed to appear, but brief is not. But I find that the tax effect is less. But from the brief, I find subject to correction. But I don't have the. I think it's 9 lakhs and not subject to. You also will find in the appellate order subject to correction. Whether any audit objection was there or not, to that I have to take instruction. Otherwise, not.
Nine lakh 72,000. Please come. This appeal has been filed by the revenue under section 260 capital A of Income Tax Act 1961 within bracket the Act, challenging the order dated July 12, 2012, passed with Income Tax Appellate Tribunal, C Bench Calcutta within bracket Tribunal in ITA number 358/K1/2012 for the assessment year 2008-9. The revenue has raised the following substantial questions of law for consideration. Page number 3 of the stay application 1 and 2. We have heard Mr. Prithvi Dorial and its standing counsel appearing for the appellant revenue. As could be seen from the assessment order dated December 3, 2010, passed under section 143 within bracket 3 of the Act, the total tax involved in the instant appeal is rupees 9,72,639. If that be so, the revenue cannot pursue this matter any further, as the tax effect is far below the threshold limit fixed by the circular issued by the central bank. Accordingly, the appeal stands disposed of on the ground of low tax effect. The questions of law suggested by the revenue are left open.
Grateful, ma'am.
Item number 5.
I'm appearing. I think this is also not similar. Right? Subject to correction, not here also not tax effect. Check. Subject to
79 lakhs. The same order. So the preamble you please take from here. Substantial questions of law. Page number 5, only one question. Assessment order, one second, dated December 31, 2009. Under said 143.3, here it will be section 115, capital W, capital E, bracket 3 of the Act. Next.
Next,
Number 6.
and I'm the beseeching your lordship, kindly take it up not tomorrow, my lord. He's also in difficulty. I'll have a copy of that.
Wow, what is the
But the issue is that the reserves of the bad debt under section 36 after the amendment, this is actually written off. The profit and loss account is debited and reduced from the
it
Sunday
is not
debits.
covered by some
This is Vijaya Bank's judgment, my lord. I'm led by Mr. Khaitan, but my learned friend says that he doesn't have anything, any copy.
you give him a copy.
My lord, I'll give.
Wednesday,
Yes, my
at the request of the learned advocate for the appellant, so and so appears for the response.
lord. Guys, my lord.
Item number 7.
The last occasion, my lord, this matter should be tagged with the writ petition order. So this is the order which was passed.
If I may remind my lords, but there was a delay in filing the return, consequent to which the deduction under section 80I was denied, 80I and 80IB. So whilst the matter was pending in the appellate forum, an application had been made before the Central Board of Direct Taxes for condonation of that delay. As a matter of law, that question as such is against the assessee by decisions of our court. So when the matter had come up, I had made this submission and pointed out that there are decisions against me, but this matter was pending before the board. So my lords were pleased to direct that the board should take a decision on that. So that board decided it adverse to me. Writ petition was filed, and then writ petition was referred. It was pointed out that the matter is in appeal before my lords. So writ petition has been referred before my lords.
So it is tagged today?
Today it's not there in the list. It needs to.
But I have already given an assignment order. So list the writ petition in WP number so and so along with this appeal. In terms of the order of assignment passed by the Chief Justice. Next week. So first the writ has to be heard.
Yes, ma'am.
But have you filed your affidavit in opposition?
Opposition.
Already, let it come next week.
Item number 8.
I am for the appellant, my lord. Here the issue involved is whether the sales tax, remission of sales tax subsidy is a capital receipt or not. Under the West Bengal, it is already decided issue, my lord. And it is for the assessment year 2005-6. And for the same assessee, for the assessment year 99-2000 to 2004-5, on the basis of the year assessment year 2004-5 and 3-4, the tribunal decided the issue. Even the matter is in my favor. Because the tribunal's contention is because we cannot deviate from our earlier stance, because that even now the judgment in your favor, because the earlier year it is against you. So my lord, my humble prayer, my lord, I am pressing the others year's ITA number. May all the assessment year may be clapped with this year and may be taken up in the any other day subject to your lordship convenience. It is at relevant page, paragraph, page 20. at page 20, my lord, and paragraph 31. It is for the purpose of industrialization in the backward area, my lord. And it is under the West Bengal Incentive Scheme 1993 at para 31.
But there is one, I think we also decided this issue.
Yes, my lord, in the favor of the assessee, my lord.
You're carrying any judgment?
No, today I am not carrying any judgment because of that the earlier year maybe clapped and then we can argue the matter.
We have heard so and so. It is submitted by the learned advocate appearing for the appellant assessee that in respect of other assessment years, appeals are pending before this court on the same issue, and they have also been admitted. Hence, registry is directed to list the following appeals along with this appeal.
This is the appeals number, my lord. I have had hand over the appeals number. Identical issue is involved in all years. Yes.
ITA number 405 of 2008, 406 of 2008, 266 of 2008, 407 of 2008, 16 of 2021, 72 of 2018. Let it come after 2 weeks. In the meantime, if papers are not there with Mr.
Yes, I will serve. No problem.
I hope, my lord, in all the matters I am not appearing.
You please appear.
কোনগুলো নেই আমাকে বলবেন?
In order to have continuity, we have directed Mr. Samrajit Roy Saudhary, learned senior standing counsel, to appear for the respondent department in all the above mentioned appeals. If no other advocate, it has already been nominated to appear for the department in the above appeals. If they have already nominated, well and good. Otherwise,
Monday week, my lord. Monday week.
New application of tax matters, item number 9.
My lord, for item number 9 and 10, I am appearing in behalf of the respondent, my lord. We haven't received the copy of the petition yet. I'm led by...
I'm serving in.
Your colleague is here in court. She has been given the copy.
My lord, kindly fix a date after 2 weeks. I'm led by...
All right.
Mr.
We have heard Mr. Subhash Agarwal also, and Mr. etc. There is a delay of 81 days in filing the appeal. As the explanation offered is acceptable, the delay in filing the appeal is condoned. So let it come after a week.
The delay has been conducted.
Next.
9 and 10 the same.
9 and 10 same.
Item number 11.
I'm for the appeal, my lord.
9 and 10.
একই তো 85 days আছে
Yes. 11.
Item number 11.
Lord, I am appearing for the appeal. There is a delay of 167 days, my lord.
Who will appear for the department?
Yes, sir.
17th July. 17th July.
17th July, my lord, it was sent. No. Income tax. Income tax.
Right. CIT judicial.
No.
Income tax department. They have served to the department, but CIT judicial has to be served. They have served to the department, I believe, not the CIT judicial.
Manoj,
That's why, my lord. We have not been engaged. Nobody was engaged as well.
issue is very short, my lord, in this case. कर देंगे भाई, टेंशन नहीं।
No, whether 43B is the issue or
Yes.
unexplained,
43B.
but it has been sent back.
My lord, there is no need, my lord. Why I am submitting, my lord? If we do not claim any deduction, my lord, under section 43B, because my gross profit was on estimation basis.
8%.
8%. Therefore, my lord, we do not claim any deduction. Therefore, if there is no claim of deduction, my lord, there is no question of addition, my lord. And it is covered by this Honorable Calcutta High Court judgment, my lord, and several other High Court judgment, my lord. And the kindly see, my lord, appellate authority's order, my lord, page 20, my lord. Kindly come to last paragraph, my lord.
Page 22.
Page 20. 20 of stay petition.
Yes.
From the above, it is clear that AO has replaced the figures of profit, rupees such and such, shown by the assessee for rupees 3 crore 58 lakhs. Now, my declared income was 1 crore 78 lakh. Thereafter, since 8% was, my lord, profit was added, the income comes to, my lord, 3 crore 58 lakhs, which was computed by the AO as at 8% of the gross profit. Once the AO has computed the net income under profit and loss account, under business and profession, it is presumed that all the provisions of section 29 to 43D have been considered and no further addition on account of section 43B is required. Therefore, the addition made by the AO under section 43B are not required. The issue is covered by the decision of this Honorable Calcutta High Court. In the case of Arjun Bhaumik versus CIT, the decision is as under. Kindly skip first paragraph. Ms. Smita Das, the advocate for the appellant, the court. The appeal has been filed under section 268 of the Income Tax Act 1961 against the order dated such and such passed by the Income Tax Appellate Tribunal B bench for the assessment year 2008-9 on the following questions: whether on the facts and in the circumstances of the case, the tribunal was justified in law in not applying the provision of section 40A IA of the said, being specific disallowance for money. This is not important. Question number 2, whether on the facts and in the circumstances of the case, the tribunal was justified in law to direct the once the profit rate at estimated. Further disallowance on same books of account cannot be made in the light of the provisions under section 40A IA of the said act. Thereafter, kindly come to skip the third question. According to her, such additions were applicable under section 40A IA. We find that the learned tribunal, while allowing the appeal of assessee, had held as under. We find that there is no dispute that there are no books of account as the assessee failed to produce the same. Similar is our case. It is also an admitted position that assessee has accepted the application of net profit rate at the rate of 8% on the gross receipts. The dispute only is as regards to disallowance on account of higher charges, transportation charges, and slurry removable charges by invoking the provisions of section 40A IA of the Act. Further disallowance of the supervision charges, labor charges, site expenses, load testing expenses at the rate of 50%. Whether the AO can disallow the expenses which are directly related to gross receipt of the assessee, on which the AO has estimated net profit by applying the rate at the rate of 8%. It is a fact that the assessee has not produced books of account. It means that the AO has not relied on the books of accounts for estimation of profits. The fact is accepted by assessee as well as the revenue. We are of the view that once the net profit is estimated, the AO cannot base his disallowance on the same books of account for the purpose of disallowance of invoking the provisions of section 40A IA of the Act as general disallowance under section 37 of the Act. The estimation made by the AO of net profit will take care of every addition related to business income or business receipts, and no further disallowance can be made. We see force in the argument of the assessee, and when the income of the assessee was computed applying the gross profit rate and no deduction was allowed in regard to the expenses claimed by the assessee, there was no need to look into the provision of section 40A(I)(A) of the Act or section 37 of the Act. Now, Delhi High Court's judgment is based on the section 43B. Paragraph 4. In appeal, the tribunal was of the opinion that in view of the provisions of section 43B of the Income Tax Act 1961, since the assessee had not claimed a deduction, there was no question of disallowing the deduction which was not even claimed. The relevant extract of the section 43B of the Act reads as follows. Thereafter, the section 43B was quoted. Learned Counsel for the Revenue urges that the decision of the Calcutta High Court in the Chowrangi Sales Bureau Private Limited vs. Supra covers the point in its favor. We are unable to agree. In that case, it was held that the liability to pay sales tax arose the moment a sale or purchase was effected, and if assessee was maintaining accounts on the mercantile system, it would be entitled to deduction of the estimated liability of sales tax, even though such sales tax had not been paid to the sales tax authority. The question there concerned was the entitlement of the assessee to deduction under section 10(1) or 10(2) Roman 15 of the Indian Income Tax Act 1922. The decision is clearly distinguishable in its application to the present case. Here we are concerned with the assessee who has not even claimed any deduction on the ground of service tax and has not debited the amount to its profit and loss account. Moreover, the provisions of section 43B of the Act are quite clear in this regard. The decision of Calcutta High Court in Chowrangi Sales Bureau was not in the context of applicability of section 43B of the Act. In our opinion, since the assessee did not debit the amount to the profit and loss account as an expenditure, nor did the assessee claim any deduction in respect of any amount, and considering that the assessee is following mercantile system of accounting, the question of disallowing the deduction not claimed would not arise. Learned Counsel for the Revenue submits that the assessee has sought to evade the tax under the mercantile system of accounting. We are of the view that it is not the revenue authorities to tell the assessee how to maintain its account. Therefore, my lord, we did not claim any deduction under section 43B when the gross profit is estimated. My lord, kindly see the Honorable Madras High Court's judgment, my lord. Paragraph 12.1, my lord. Very good. Paragraph 12.1. The next question raised by appellant revenue relates to disallowance of a claim under section 48(3) of the Act. For better appreciation of the issue, section 48(3) of the Act is extracted below. Paragraph 13, my lord. On the issue relating to disallowance under section 48(3) of the Act, the same was considered by the CIT appeals by holding that income has been arrived at an estimate of turnover and computed applying the gross profit, and therefore no expenditure shall be allowed, since the gross profit applied would take care of the amount incurred by the purchases, etc. The CIT appeal to justify the said stand drew strength from the decision of this court in S. Muhammad Dhurwadin's case, Supra, wherein court has held thus. The question for consideration is, when no deduction was sought and allowed under section 40A(3), was there any need to go into section 48(3) and rule 6DDJ? We see force in the view taken by the tribunal that when the income of the assessee was computed applying the GP rate, and when no deduction was allowed in regard to purchases of the assessee, there was no need to look into the provisions of section 48(3) and rule 6DDJ. No disallowance could have been made in view of provisions of section 48(3) read with rule 6DDJ. As no deduction was allowed to and claimed by assessee in respect of purchase, when GP rate is applied, that would take care of everything, and there was no need for the AO to make scrutiny of the amount incurred on the purchases by the assessee. Following the ratio laid down by this court in the aforesaid decision, the CIT appeal held that the addition made under section 48(3) of the Act are to be deleted, since the basis of the addition had been faulted and are no more valid and since the income is estimated, no disallowance on this account can be made. The said view of the CIT appeal has been affirmed by the tribunal. This court has already held in the former portion of the order that the assessment order came to be passed only on the basis of the so-called judgment. Thereafter, it is not important. So, when the gross profit is estimated and my income is estimated, that income includes all the expenses. Therefore, there is no need to further adding back the expenses which I have shown in the PL account. And this is but I'm also relying upon Allahabad High Court judgment.
So the remand was unnecessary.
Yes, my lord. Short judgment, my lord. Kindly turn to next page, my lord. Kindly skip, my lord, first 4 lines. The assessee then appealed to appellate tribunal, which did not record a clear finding on the question whether the price paid by the purchases amount to expenditure stating that the appeal could be disposed of on other grounds. The appellate tribunal, however, accepted the contention of the assessee that no addition could be made by the assessing authority under section 48(3) of the Act, as no deduction was claimed in respect of purchases. The tribunal observed that the assessing officer rejecting the assessee's trading results under the proviso to section 145(1) of the Act had computed the assessee's income by applying the gross profit rate of 15% on sales as shown in the head office as well as in the branch office. The tribunal further observed as follows. The question arises whether in such a case any deduction on account of purchases is at all allowed to the assessee, though it may be true that a gross profit rate of 15% was fixed, keeping in view all relevant facts, including the purchases made by the assessee. Inasmuch as we are of the view that no deduction as such having been allowed to the assessee on account of purchases, we hold that no question of any disallowance on account of purchases can be made in this case under section 48(3). All the 3 questions referred to in this court revolve around the same controversy. The question for consideration is when no deduction was sought and allowed under section 48(3), was there any need to go into section 48(3) and rule 6DDJ? We see force in the view taken by the appellate tribunal that when the income of the assessee was computed applying the gross profit rate and when no deduction was allowed in this regard to the purchases of the assessee, there was no need to look into the provision of section 48(3) rule 6DDJ. No disallowance could have been made in view of the provision of section 48(3) read with rule 6DDJ, as no deduction was allowed to and claimed by assessee in respect of the purchases. When gross profit rate is applied, that would take care of everything and there was no need for the assessing officer to make scrutiny of the amount incurred on purchases by the assessee. There are several other judgments, my lord, but
the assessing officer, in the body of the assessment order, he doesn't say anything about
nothing, my lord.
The computation he adds.
Yes.
Because assessee accepted already 8% you fix it.
Yes.
And he rejected all the profit and result of the profit and loss.
Therefore, the expenses are not
disclosed in the return was rejected. And 8% was fixed.
Yes.
But no reason given for why 43B has
is
been
applied. But my lord, the appellate authority, my lord, considered and my lord passed the regent order. Appellate authority has considered, my lord.
Yes, he has considered.
I mean, he has given the chart relating to our computation of the tax, my lord, as per our return and as per the assessing authority.
Relied upon some Andhra Pradesh High Court. No.
Andhra Pradesh, yes, my lord.
Indwell construction.
Yes, my lord. Yeah.
But,
and on Chhattisgarh's judgment is also there.
Which High Court?
Chhattisgarh High Court. Madam, kindly last paragraph. Madam.
Last paragraph.
Madam, page 2. The pattern of the assessment under the income tax is given by section 29, which states that the income from the profit and gains of the business shall be computed in accordance with the provisions contained in section 30 to 43D, and ours is 43B. Section 40 provides for certain disallowances in certain cases, notwithstanding that those amounts are allowed generally under other sections. The computation under section 29 is to be made under section 145 on the basis of the books regularly maintained by the assessee. If those books are not correct or complete, the income tax officer may reject those books and estimate the income to the best of his judgment. When such an estimate is made, it is in the substitution of the income that is to be computed under section 29. In other words, all the deductions which are referred to under section 29 are deemed to have been taken into account while making such an estimate. This will also mean that the embargo placed in section 40 is also taken into account. No doubt there is a big difference between the profit earned and with own capital and profit earned with borrowed capital. And such a difference could have been taken into account by the income tax officers while making an estimate. If the commissioner had set aside the estimate on the ground that the vital fact that the business was carried on by with his own capital and not with the borrowed capital has been ignored by the income tax officer, there may not have been any difficulty in upholding that order. But when he proposes to add back an exact item in the profit and loss account, he was relying on the rejected books, which he could not do as held by the bench of this court in Modi Sudarshan Oil Mills Company. There is also a further difficulty if section 40A, as argued by the learned counsel, is to be taken into account even after making an estimate. When there are certain other deductions which are to be disallowed, such as wealth tax payment in section 40, can it be said that after making the estimate, the wealth tax charged in the profit and loss account should again be added back to the profit?
Chhattisgarh, you said?
Paragraph 11. Relied upon the Delhi High Court's judgment, madam. On 43B, my lord, it's
So here also in the books of accounts or
Yes.
profit and loss statement,
Yes.
you did not claim
no,
43.
no.
And you said Calcutta High Court is there.
No, Calcutta High Court judgment has been quoted in the appellate order, my lord. We tried to download, my lord, but it was not there.
You can take notice to the difference. This appeal has been filed by the assessee under section 260 capital A of the Income Tax Act 1961.
आपको कौन सा दिया है judgment?
Challenging the order dated 23/9/2020
सब दे देंगे.
passed with Income Tax Appellate Tribunal C bench
एक बार दे दीजिए,
in ITA number 3542/K1/2019 for the assessment year 2012-13. Though the department has been served, since no standing counsel has been nominated by the department, we have directed Mr. Procedural and a senior standing counsel to appear for the respondent department, and his appearance shall be regularized and his fee bills be honored. Para. There is a delay of 167 days in filing the appeal. The explanation offered by the appellant assessee is acceptable. Apart from that, the delay is not inordinate. Hence, the delay in filing the appeal is condoned. GA 1 of 2025 is allowed. Para. The issue involved in the instant case is whether the learned tribunal was justified in setting aside the order passed by the appellate authority, namely Commissioner of Income Tax Appeals for Kolkata, within bracket CITA, and remanding the matter to the assessing authority to consider whether addition is required to be made under section 43 capital B of the Act. The assessee has raised the following substantial questions of law for consideration. Page number 4, question A, B not required, C, D not required, E, F, G not required. That's all. We have heard so also. The assessee filed its return of income for the assessment year under consideration, AY 2012-13, disclosing a total income of rupees 3, 66, 69, and notice under section 140 subsequently the question of section 142 appeal for the assessing officer published the details. First question is considered with regard to the profit of civil construction business. In accordance with the stand taken by the assessing officer rejected the books of accounts and estimated the net profit of the assessee at equal as was done to the earlier assessment years. However, computation of the tax levy, the assessing officer added liability under section 40 and passed the order dated 29/2022 under the addition made on section of the Act that the appeal officer in the assessment order did not discuss why it's important section 40 separately when it was estimated by the assessing officer. And the assessee agreed to pay tax on the taxable income determined at 8% of the turnover. And therefore, computation of the courts applying the exclusions is no way applicable. Party side could consider the submissions of the assessee and then once the assessing officer completed the net income under profit and loss provision, it is presumed that all the provisions of section 21, particularly B, have been considered and no further addition on account of. Therefore, the additions made by the SC officer under section 40 are not required. With regard to the appellate authority to note the Commission of Income Tax 70, Roman 70 versus Sri Arjun Gopi, 24 of 2014, dated 29 and allowed the letter to quote the submissions and held them matter has to be restored back to the private proceeding officer who has to verify the claims with respect to that. That's liability. Paying already suffered tax on account made under section 42 of the Act in the proceeding aggrieved by such order of remand as to the association for the present. By this court, as well as the order of provision of the other courts. Arjun Bhumi, Sri Arjun Bhumi, Honorable Division Bench said that when profits are estimated, it means the assessing officer has not relied on this. And if this fact is accepted, then the estimation made by the assessing officer of net profit will take care of every addition related to business impact or business receipts, and no further disallowance can be made. Similar issue arose for consideration because of Commission of Income Tax versus Noble and Limited I capital 2166 tax line wherein it was said when the assessor has particular on the ground of service tax and has not debited the amount of profit and loss apply further deduction under section 40 was impermissible. And it is like that the income of the SC was completed after gross profit, and when no deduction was allowed in regard to purchases of the assessor, there was no provisions of section 40 capital and 6 capital that is not and no pura dupli. IPR 776 that where the books of accounts of the assessee were rejected and its income was estimated by proviso to section 145. There was no separate action on account of interest and salary paid to the partners could be made to such estimate. In Commission of Income Tax, our chief versus Amman Steel and Allied Divisions, 2017 79 taxman of complete 155 Madras. Yes, sir.
जो दिखाएं तो मेरा कॉपी
That when income has been arrived at and at the estimate of value and completed apply the gross profit. No expenditure shall be allowed. Since the gross profit applied to take care of the amount incurred by purchases, etc. Court noted the decision, the earlier decision in CIP versus Mohammed Durab tax case within bracket A number 5 of 2007, dated 11/7/2007, within bracket Makassar. Wherein it is sent as follows. Start the row. That is given. And motors tax officers. 2000 Vehicle Fitting for 169 taxman.com. For the court mobile and image. Within bracket I, within bracket T, within bracket G. That the assessee did not to the profit and loss account as an expenditure, nor did the assessee take action in respect of chart number 2 that the assessee is following the mercantile system of account. The question of disallowing not claimed with the others. In the about and also the unexcluded fact that the gross profit was estimated after rejecting the books of accounts. The order passed by the learned tribunal restoring the matter to the assessing officer necessary and not possible. For the other reasons, the appeal filed with the assessee is allowed. The substantial questions of law are answered in favor of the assessee, and the order passed by the CAP dated 1920 stands restored.
I'm good.
Contempt matter, item number 12.
Well, I have the petitioner in this matter, my lord, appearing, my lord, virtually. Here, my lord, if your lordship kindly see your lordship's order, my lord, that has not been complied with by the respondents. Here, your lordship's directed at paragraph 29 that the amount has to be paid by 15th July.
Page 48.
Site appeal to Supreme Court.
No, my lord.
No, my lord.
Let a copy be
The
served.
order dated 1st July 2025.
Now,
And
please ask your junior to serve a copy of
yes,
the
my lord. Yes, my lord. I will.
Copy it up after 4 weeks. I will come back with something before your lordship. I will convince my client because I think the order is very.
Have it after 2 weeks, then we will require.
Yes, lordship.
You have heard this Partho Ghosh and advocate appearing for the applicant. The suspended Banerjee learned counsel appearing for the alleged contempt. Let a copy of the contempt application along with annexes be served on the learned advocate on record for the respondent, who granted time to get instruction in the matter as to why the order and direction issued by this court has not been complied with. List the matter under the same caption after 2 weeks.
I'm deeply.
Grateful, your lordship.
For admission of tax matters, item number 13.
Let I for the.
I appear for the respondent assessment.
Miller, this matter, Miller, the assessee had Miller issued shares to Miller 3 individuals at Miller the price of the share at par and Miller 8 Miller companies at a premium. Now Miller, these companies, your lordship will kindly take page 14 of the assessment order, where these companies, the assessing officer has found that they are either do not exist or they have filed nil return or Miller, they do not have any kind of business. And their list has been given at page 14. Now Miller, the tribunal, surprisingly, but before I take you to a tribunal, Miller, kindly see page 87, where Miller, the 3 persons, Shashi Mehta, Amit Mehta, and Kunal Mehta, were issued share at par. And Miller, the rest of the companies were issued, they were issued share Miller at 700 or 490 rupees. 490 rupees per share. And Miller, the rest of the companies who were given shares on premium, though these companies did not have any Miller business whatsoever or income. Now Miller, kindly see page 105, 106 Miller of the tribunal's order. The reason why the tribunal has set aside the order of the assessing officer is, Miller, that the assessing officer has not bothered to discuss on point or point out any defects or deficiencies in the documents furnished by the assessee to the share subscribing companies. Now, Miller, this is Miller after having discussed so elaborately about those companies. Miller, how could Miller the tribunal come to the conclusion that nothing has been looked into? And then Miller, the tribunal decided that these evidences furnished have been neither controverted by the learned assessing officer during the assessment proceedings, nor anything substantive brought on record to justify the addition made by him. The assessing officer simply added the amount of share capital and share premium on the grounds that the assessee has not produced the directors or shareholders. Miller, after having discussed all the companies and the Miller, their credentials, Miller, they are then only that directors and shareholders were called for, because these companies, Miller, had almost nil operation. In each and every company had nil operation. And at page 15, the assessing officer has recorded from the above discussion, it is clear, leads to the inference that 8 subscriber companies were incorporated having no visible business activities and creditworthiness to make the investments.
threshold limit matter তোমরা করছো against the directive of the finance minister গত সপ্তাহে finance minister instruction দিয়েছে CBDT to withdraw all these appeals.
What did the appellate authority do? It confirmed.
The CIT appeals confirmed. That order, your lordship will kindly find from page 80.
Starts from page 20.
And his observations are from page 85.
Page 85.
85.
From 84.
Yes, we have instructed CBDT on the appeals within 3 months. Very much. আছে ওই শেয়ার প্রিমিয়াম অ্যাসপেক্ট আছে বারবার
So identity of the shareholder was proved.
Yes.
According to you, the creditworthiness and genuineness have not been established.
Yes.
Well, the tax effect is 48 lakhs. It does not fall within the exception clause of the monetary limit circular of 5 of 2024. This is not
organized tax evasion, clause B.
Well, with relation to accommodation entry, that is not the finding of the AO. There is no finding of the assessing officer. There is a case of accommodation entry. There is a finding of the AO that shares have been purchased at high share premium. That does not fall within the exception clause to the circular 5 of 2024. But last week, the finance minister gave a specific direction to CBDT that all these appeals which are below monetary limit should be withdrawn within 3 months. And that was reported in all the leading newspapers.
You didn't read
not seen it.
But I have a case on merit also.
Because in para 25 of the stay application, page 10, they say the case falls under the.
Yes, that is H. That is paragraph 3H. If your lordship kindly take, may I just read out paragraph 3H for your lordship's kind consideration? I'm sorry. 3H is, my lord, cases involving organized tax evasion, including cases of bogus capital gain or loss through penny stocks. This is not a case of penny stock. And cases of accommodation entries. Neither it is a case of penny stock, nor it is a case of accommodation entry. This is the only exception clause which can be placed into service by the department.
Yes. On merits?
On merits, kindly, my lord, take. Kindly take, my lord, the appellate order, CITA order. Kindly take, my lord, what was submitted before the appellate authority. Kindly take, my lord, page 30. Page 29 of the appellate order. With respect to each and every share subscriber or applicant, all the details were furnished. With, my lord, in cases of companies, the paid up capital and the reserves also provided. The details thereof have been provided. To, my lord, kindly take Anamika deal mark. Free reserves and surplus, my lord, kindly take the figure. Kindly take Bholenath Commercial. Then, my lord, Abha Commercial. Then, my lord, Aaron Taya Private Limited. Then ISOR, Rose Commercial, each and every company. Radhesham Deal Trade Private Limited. Why this is happening? I'll tell your lordship, kindly take the assessment order for once. But this is the practice which is being adopted. Why? The reason is at the end of the assessment order. Kindly take your lordship, will find there is a note not for the assessee at page 19, which they have included in this appeal, which was not made known to the assessee, but now it is part of the appeal. The reason given for selection of the case under CAS had been looked into the reason for large share premium received. So that is the only reason, my lord, there is nothing else. Summon under section 131 was issued to the signatory director of the assessee company, and the same has been considered in the assessment order which are placed on record. Due to restructuring of the department, CBDT's notification number so and so dated 22/10/2014 and consequent change of jurisdiction, mass transfer in and out of records took place, which consumed time and manpower of the ward. For the 18 numbers of time-barring scrutiny cases were received from different wards as per the new jurisdiction, and though thorough intent for investigation have been made in this short span of time. It was a hurried assessment. One time, your lordship has held recently, my lord, in one of such cases, gave me the which date. That, my lord, mere non-appearance of the directors of the share applicant companies, my lord, that will not be a pointer towards the fact
That kindly take, my lord. This is wish realty.
There is no call in on.
My lord, this is the only case. And my lord, kindly take, my lord, now the tribunal order. So my lord, everything was explained to the CITA. Page 3 onwards, my lord. Everything supplied with respect to each and every share applicant company. Now, my lord, kindly take the IT-80 order, which starts at page 99. My lord, kindly take, my lord, paragraph 6 first. This is a submission made on behalf of, my lord, the assessee. That is the appellant before the tribunal. Each and every company details of the net worth and the amount paid towards the share subscription is tabulated. Then, my lord, kindly take paragraph 11 to 11.2. Documents were furnished to the assessing officer. Neither been controverted by the learned AO during the assessment proceedings, nor anything substantive brought on record to justify the addition made by him. The learned AO has simply added the amount of share capital and share premium on the ground that the assessee has not produced the director shareholders. This is the reason, because the note which is not meant for the assessee says that 131 was not responded to.
No, that CIT also accepts.
That CIT also accepts. My lord, kindly take how the first appellate order has been dealt with by the learned tribunal at paragraph 11.1, which is at page 107. A perusal of the impugned first appellate order shows that the learned CITA has not discussed anything about the material facts of the case. He has not pointed out any defect and discrepancy in the evidences and details furnished by the assessee, but simply cited certain case laws even without pointing out as to how these case laws were applicable to the facts of the case. By simply reproducing contents of the case laws without discussing about their application on the facts of the case, in our view, would not make the order of learned CITA a justifiable speaking order, and hence the same is not sustainable as per law. From the facts and circumstances of the case as already discussed, we find that the case of the assessee is squarely covered by the decision of the Honorable Jurisdictional High Court in the case of Nayana Distributor. This is your Lordship's judgment. NHO? No. This is reported now, but Malad, I have got the unreported version.
What is the citation?
Malad, citation I am giving your Lordship right now. Malad, this is reported in 2023-6 TMI 1362. আছে ওটা তাহলে এটাই তো দেবে actually when we are taking printout from TMI the fonts are little bit enlarged, so that's your difficulty, but we have the print the reported version also. You know, reported চাই
Yes.
So my respectful submission before Lordship would be, my lord, no substantial question of law arises, and this is also barred by the threshold limit circular, my lord. These are my respectful.
Yes. Anything else? Any decisions you want to?
Milord, nothing more. Milord, whatever the assessing officer said, Milord, he has said in details, and Milord, he has shown that none of the companies, Milord, actually has any kind of business whatsoever, or are in a position to advance such kind of a, Milord, share premium to the
My answer to that would be, it is not the business of the assessing officer
It's a reply
to
a
find out whether there is a business of the assessee concerned.
reply to a reply.
BST infratech, my lord, I do not have BST infratech, my lord judgment. My lord judgment, BST infratech. BST infratech, my lord past judgment, when the my lord has held that the source of source has also to be looked into. My lord, this I do not have. Yes, my lord, reported, my lord.
But
There are
that
two
is not
judgments
the
on this
finding.
aspect.
That is
One
not
is NR.
BST infratech is reported, my lord. BST infratech is reported.
What do you say about that exception clause? They say it's not a case of organized tax evasion. It is not, what do you say?
Well, may I
The
give your
penny-
lordship the exception clause?
Hey,
My
Not a
lord,
penny stock.
Accommodation entries, my lord.
no, there is no finding. There is no finding of accommodation entry here.
The unexplained cash credits. So these are money were routed. So these are accommodation entries.
দেখেছো তুমি রিপ্লাই বলছে তোমার রিপ্লাই পর আবার অমিত বলছে চলছে মানে অমিত হ্যাজ টেকেন ওভার
নিয়ে গেছে
এটা মানে lordship was pleased to deliver another judgment in the case of wise investments where lordship had the occasion to consider once again BST. But in that case, kindly take, Mala, this is an unreported version. In that case also, my lord, one of the case made out by the department was that it was a case of high share premium. Your lordship was pleased to consider the judgment rendered by Bombay High Court Division Bench that whether a share should be sold at what price, well, that is an internal business of the companies.
But what they say is,
yes,
3 individuals you gave it on par.
That part.
For companies you put it at 490.
490.
Right. Premium. That they want to compare.
So what is the justification when these?
Well,
for
that is
charging this?
exactly what has been answered by Bombay High Court. And my lord, your lordship
My lord,
has
there are
also
rules
taken
11.
an similar view, identical view.
Appellant company was showing obviously good results, prospects, growing company.
But substantial question of law number 3.
Yeah, the facts were different. All right, we'll consider.
My lord, I will supply these two judgments, my NRA steel, iron and steel, and BST infratech, my lord. My lord, I'm apologizing. I had those judgments, but at this moment, where I
You can do it during the course of the day. We have heard so and so judgment result.
Lordship will kindly consider paragraph 13 of your lordship's judgment in wise. 13 and 14.
আমার কপি দিল না
Grateful.
Item number 14.
Lord, I beg to appear on the appellant, my lord. Lord, small issue, my lord. Here is even an addition under section 69A. But my lord, ultimately tribunal find that the notice under section 148 was not valid. It is bad in law. My lord, here is the case is that, my lord, the assessing officer case is that, my lord, investment made in a Jama Kharchi company. Now, my lord, the CIT appeals also confirm the, my lord, addition of the, my lord, assessing officer. My lord, finding of the, my lord, CIT appeal is that, my lord, assessee did not, my lord, file the cogent documents. But, my lord, tribunal will not find that, my lord, the assessing officer, my lord, did not, before issuing, my lord, 148 notice, my lord, assessing officer did not, my lord, make proper inquiry. And, my lord, in earlier year also, my lord, it is 13, 14, 12, 13, my lord, the 12, 13, the assessing officer also, my lord, not made any addition
in respect of that. Our case is there, in case of 1213, the addition could not be made because the time period of issuing 148 notice expires 6 years expires. That is the point. But your lordship kindly see some portion of the CIT appeals order from page 43. The tribunal gone into the fact that there is no occasion to addition of 35 lakhs because the assessee could not receive 35 lakhs. It is a clear case that assessee received 20 lakhs only. But from the CIT appeals order, it appears that assessee did not file any document to show that he has received 20 lakhs. Your lordship kindly see page 43. Paragraph 5.1, 5.2, and 5.3. And 5.3.1 million, last paragraph, last finding of that issues. And in earlier paragraphs, in paragraph number 4, the CIT appeal was pleased to held that the 148 notice issued by the AO is valid.
Page number, para 4.
Paragraph number 4 is start for 28, CIT appeals order 28. This is the ground of 1 and 3. Now 4.2 the submission of the SSC in detail. And formula page 42, para 4.3.
Are on page 28.
Yes. But here reasoning is that when the 35 lakhs, the assess's case is that assessee did not receive 35 lakhs.
So they have denied that they have, the receipt of 35.
Yes, they have denied but the in the CIT appeal stage and before the assessing officer, that facts did not come because the tribunal 35 lakhs.
So assessee submitted page 38. After the no bench decision, last paragraph, 10 lines from the bottom. Assessee submitted that he had received rupees 20 lakhs from Burma, Brahma, and not 35 as stated. Incorrect assessment.
Then that is the fact finding by the ITAT also, my lord.
So the assessee sought for some information that was not given.
That was not given. My lord, but my lord will kindly take page 47 of the ITAT order for a moment. Point 3.1. My lord, may kindly have a look at the learned counsel for the assessee in the course of argument gave force on this additional ground by submitting that there was nothing brought by the AO with respect to the amount received as alleged to the tune of 35 lakh. Though the burden lies upon him, learned counsel for the assessee further submits that the AOs before issuing notice had to verify the genuineness of the credible information, but the AO did not do so. Hence, accordingly, the issuance of notice is bad in law. Learned counsel further drew the attention by saying that had AO had no information of 35 lakh, and in reality there was a receipt of 20 lakh from the said party. My lord, Marcus, he has filed the statement of bank account that shows that receiving of 20 lakh from Mrs. Brahma Trading on 11/7 and 18/7/2012. The learned counsel further submits that for AY 2012-13, the reopening was initiated against the SSE on the same issue, and it is after verification and details, after being satisfied, it was dropped. My lord, we had asked for them. My lord, we categorically say that we have received only 20 lakh. The information, all the documents were given. My lord, there were 3 replies filed before the assessing officer. There were 3 replies. The bank statements, everything was given. So, my lord, there's no live link here, my lord. My lord, may take my lord page 49.61.6.1. My lord, the tribunal categorically records there is nothing brought by the AO with regard to the receiving of 35 lakh, save and except this fact that he had received credible information. The AO failed to provide any details of the alleged receipt of 35 lakh from the said party at any point of time. And my lord, then at page 50, my lord, point 7, the findings of the ITAT says the ITAT holds that only on the basis of the information from investigation wing, they have made an addition. There was no independent application of the mind by the AO. And my lord, they also rely on the order of the 12-13 minute that. So it was considered and it was dropped. My lord, there's no inquiry. Only they've received information and they made an addition. My lord, the tax effect is also 10 lakh rupees. My lord, tax effect is 10 lakh, though it is there under the exception, but it is only 10 lakh rupees.
This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 bracket the Act is directed against the order dated 2/5/2024 passed by the Income Tax Appellate Tribunal B Bench Calcutta in ITA number 265/KOL/2024 for the assessment year 2013. The revenue has raised the following substantial questions of law for consideration. Page number 7, sir. 1, 2, and 3. We have heard so also. The assessment for the year under consideration was reopened on the ground that the assessing officer had reason to believe that income chargeable to tax has escaped assessment within the meaning of Section 147 of the Act. Notice under Section 148 was issued on 19/3/2020, wherein the reasons for reopening were set out. The assessee submitted their objections by 3 letters, which was received by the assessing officer. However, the stand taken by the assessee in the 3 objections filed by them were not found acceptable by the assessing officer, and accordingly the objections were disposed of and the reassessment proceedings were initiated and completed by assessment order dated 27/9/2021. 2021. Assessing the total income of the assessee at ₹35,49,140. The tax effect in this case is ₹10,81,500. However, the revenue would state that since the matter falls under the exception clause, namely clause 3.1 within bracket H of the CBDT circular number 5 of 2024, dated 15/3/2024, that this appeal is maintained. Aggrieved by the addition made by the assessing officer, the assessee preferred appeal before the National Faceless Appeal Center within bracket NFAC. In order dated 25/1/2024, the appeal filed by the assessee was dismissed. Aggrieved by the same, the assessee preferred appeal before the learned tribunal, which has been allowed by the learned tribunal, and aggrieved by the said order, the revenue has preferred the present appeal. The first issue to be considered is whether the reopening of the assessment was valid in law. Admittedly, the assessee submitted 3 objections. Submitted their objections by sending 3 letters to the assessing officer, in which the assessee specifically sought for the information which led to issuance of notice under Section 148 of the Act. It is not in dispute that the information sought for was not furnished to the assessee. The learned tribunal examined the reasons for reopening as recorded by the assessing officer in the and proceeded to consider as to whether the assessing officer has independently considered the matter and recorded reasons for reopening the assessment. We have gone through the reasons recorded by the assessing officer, and we find that the notice for reopening is solely based upon the letter issued by the Assistant Director of Income Tax within bracket investigation, Calcutta. The allegation is that the assessee has received a total amount of ₹35,00,000,000 from Brahma Trade Links Private Limited, which is a shell company. On going through the reasons, we find there is no independent finding recorded by the assessing officer. That too, when the assessee had specifically pointed out that they have not received ₹35 lakhs, 35,000,000 from the said company, but had received a sum of ₹20 lakhs for which the sale bills have been produced. To support the stand take, the assessee had produced the statement of bank account, which shows that a sum of rupees 20 lakhs was received from Brahma Trade Links Limited on 11/7/2012 and 18/7/2012. More importantly, for identical reasons, the assessment for the preceding year, namely AY 2012-13, was sought to be reopened by issuance of notice, and the assessee submitted their objections along with details and documents, and the assessing officer, having been satisfied with the same, did not make any addition. This submission made by the assessee was found favor. Assessee was found acceptable by the learned tribunal while granting relief to the assessee. If the assessing officer had any information stating that the assessee has received a sum of rupees 35 lakhs from Brahma Trading Private Limited, and when the assessee sends a reply stating that Limited, the assessing officer, upon receipt of such information, should cause certain verification as to the correctness of what has been informed by the letter of the investigation being. In the instant case, no such step was taken by the assessing officer. More importantly, the assessing officer ought to have at least inquired into the matter after receiving the reply from the assessee, wherein the assessee has specifically stated that they had received a sum of rupees 20 lakhs only from Messrs. Burma Trade Link Private Limited, and to support the same, they had filed statement of bank account and other details. Therefore, we find on facts the learned tribunal had granted relief to the assessee, and in the absence of any question of law, much less substantial question of law arising for consideration in this appeal, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, the appeal feels dismissed.
Lord, I am led by Mr. Tilak Mitra. Lord, he is also appearing.
Yes, Mr. Tilak Mitra and Soman Bhattacharya.
Deep.
Please stop.
Permit to mention this matter for existing.
Pardon, sir?
This is a matter lordship filed and appeal, appeal has been filed, lordship. I was humbly praying to release the matter, your lordship, please.
Yes.
Grateful to
My Lord, may I be permitted to mention this matter? My Lord, I crave leave to file an appeal without certified copy.
Date of the order?
My Lord, today's date.
No, date of the order. Pass.
It is 9/7/2025.
Leave. Please call.
Appellate side matter item number 1.
I am for the petitioner. My lord. Full affidavit of service. I come against the order passed by the West Bengal Taxation Tribunal.
Assessment order in ex parte order.
Yes. What happened, my lord?
Why you didn't appear before the AO?
My lord, it was not served. It was a specific case of. My lord,
Your case is before the tribunal was assessment order not served. During the assessment proceedings, why did you not participate?
my lord, that notice of hearing, that draft assessment order was not served. That was our case, my lord. Kindly consider, my lord. They have produced one later, my lord, page 52.
Two is some tabulated statement.
Yes, my lord. No, my lord, kindly come to page 54. Sorry, my lord. Here, my lord, your lordship will find that the notices which were sent through email, those were noted only. Whether those were served or not, my lord, there is nothing. Based on this letter, my lord, this extract of the email, Honorable Tribunal came to conclusion that it has been served. We disputed. Thereafter, the Honorable Tribunal said that no, it was served, so you are asked to file the appeal. My lord, kindly see our request, my lord, page 55. Once we appeared before the authority, we prayed for time at page 55. This letter was filed on 10th December 2018, my lord. Thereafter, nothing was, my lord, communicated to us, my lord. Thereafter, all of a sudden, they said that we have issued a draft assessment order. Not that in the month of the June, which we claim that we have not received. Thereafter, they passed the final assessment order. Now, my lord, kindly consider this assessment order, my lord, kindly consider once. Based upon our documents, my lord, part of the claim of the ITC was allowed and part of the claim of ITC was disallowed on the ground that bank statement was not produced. My lord, if I have not produced the bank statement, the part of the claim of the ITC which has been allowed, it should also have been disallowed.
Please show the assessment.
My lord, kindly come to page 50, my lord, once. Last paragraph, my lord. ITC claim under section 22 of the VAT Act. ITC brought forward is nil. ITC claim allowed for rupees 2016-17 is rupees 24 crore 2 lakh 23,243 out of claimed 364,94064 on verification of official database. This balance ITC amount of rupees 1 crore 24 lakh 70,000 is disallowed as the sellers recited us has denied the sales amounting to rupees such and such. Balance ITC of rupees 80 lakh 15,000 is disallowed for non-availability of tax invoices and payments in bank statement. My lord, we have not produced any document. Part of the claim of the ITC was allowed and part of the ITC was disallowed on the ground. My lord, my humble submission. Only one opportunity may be allowed. If I succeed, my lord,
But what is this order at page 56 judgment? Mat 80 of 2022.
Page 56, my lord. This is, my lord, regarding, my lord, when the authority said that we are not in existence at our declared place of business.
Yes.
Then we filed this. We filed an application, writ petition before the Honorable Writ Court, my lord. That was dismissed. We approached this Honorable Division Bench, my lord. Honorable Division Bench, after considering that since the so cause notice was not issued, so it was not correct, and my registration certificate under the GST Act is still valid, my lord. They have restored the RC, my lord, my registration certificate.
This is under?
This is relating to that, my lord, that we are
correct, but this is under which act?
Under the GST. This is, it has got no relevance.
No, judgment is under GST. This
Yes.
assessment?
Under VAT Act. It has no relevance, my lord.
No, but then there is a finding that, but now the GST registration has been restored.
Still valid, yes, my lord. Active and valid.
And who will appear for the state? Served?
Yes, sir.
Where is your affidavit of service? Because in the assessment
He's in court number 14, his clerk, my lord.
Mr. Siddiqui.
No, Mr. Siddiqui is Mr. Tanay Chakravarti, my lord.
Tanay. Okay. Called to pass over.
Yes. I am also registered, my lord, with the FASAI. And this registration certificate is issued in 2024 and it is still valid.
Item number 2.
Item number 2, I am for the responding. Can you fix it up on this point? Because I have to take some instruction and give myself option.
Do
not
have any problem with that. If your lordship permits, I'll just flag the issue so that he can. Wednesday, you can flag all issues. Third, so and so, at the request of learned advocate for the contesting respondent, Wednesday, under the same caption. Wednesday, madam. But it may be permitted to bring on record supplementary affidavit, madam, so that I will be able to hand over to him. No, you serve copies. For the court copies, you give it on Wednesday. So I will serve. Next.
Item number 3.
I am for the appellant. But this is with regard to a writ petition filed by the petitioner under an order of confiscation for an amount of rupees 1.90 crore. Lordship will take the order impugned from the memo of appeal. But I must be candid to your lordship, in this matter I am led by Mr. Riju Ghoshal. Blood, today he is not in court. Blood, may I move the appeal only insofar as the admission is concerned, and then your lordship will fix the appeal on Wednesday if it commences to your
this
lordship.
is against a refusal to grant interim order.
No. Your lordship will kindly take the order impugned.
Matter, the learned single judge had directed the petitioner to deposit.
Yes, deposit the entire
1 crore 90 lakhs. My lord, what has happened? This is a Benami property matter. Adjudication has been done by the adjudicating authority. That order has not been challenged by the Benamdar or the beneficial owner. Subsequently, confiscating order has been passed. That is subsisting. Thereafter, now the property has to be taken. The petitioner is neither Benamdar nor beneficial owner. It is a third party. The petitioner is claiming interest in respect of that property. So this is the
your lordship will take page, the last page
my
at
lord-
para 7 of the order impugned, the direction for deposit. Paragraph 7, in view thereof, I direct the petitioner to deposit the entire amount directed to be confiscated and notified for surrender. Vide communication dated 30 June 2025 with the learned registrar general of this court within a period of 1 week from the date. In the event the aforesaid amount of such and such is deposited with the learned registrar, the same shall be invested in a short-term deposit. But the entire amount in the confiscation order has been ordered to be deposited. But we have come up against this. This order is dated 8th of July 2025.
But you are not, party to the confiscation proceedings.
But I am a subsequent purchaser from the Benamidar. But I am coming under
No, my lord, my
party
learned friend is not
interested.
aware of the facts. I'm just trying to correct you. I'm not trying to interrupt you. I'm just correcting. My lord, the petitioner's claim is that the petitioner, here, my lord, the property is money, not immovable property, land or building, it's money. The petitioner claims that that money was received in pursuance of an agreement for sale as an advance. But my lord, the fact says that I have documents which says that that agreement is not subsisting.
But that is
stands
with
there.
regard to
Okay,
the
we'll have it
factual.
on Wednesday. Let your senior counsel.
Good.
At the request of the learned advocate for the appeal.
Your lordship is admitting the appeal today?
No. We'll
Very
take it up
very
on
good.
Wednesday. Pass over Tanay has come.
For matter item number 1.
Tender apology.
The assessment order, it says that opportunity to produce the books of accounts was given, failed to produce the books. Report furnished by the assistant sales tax officer says he is not in existence in the premises. Therefore, you have sent email. But in so far as GST is concerned,
I've seen the division bench. I'll leave it.
So what?
Well, the records that I've opposed,
we will send it to the AO. Let him give him an option. Because part of
order
the
has already been, my lord. After my lord's order, I don't think I can go into that issue anymore.
this petition has been filed by.
And it has been informed Mr. Siddiqui has left. He has resigned.
He's resigned.
Right.
So you will have to take charge.
I'm trying my best.
You'll do. This writ petition has been filed by a registered dealer under the provisions of the West Bengal Value Added Tax Act 2003 within bracket the Act, challenging the order passed by West Bengal Taxation Tribunal in RN number 173 of 2022 dated 17/6/2025. The said application was filed by the writ petitioner to quash/set aside the tax recovery proceedings initiated against them pursuant to an assessment order dated 24/5/2019 passed by the sales tax officer Netaji Subhash Road Charge. The case of the writ petitioner before the tribunal was that no notice was issued to the writ petitioner. The draft assessment order was not communicated and an ex parte assessment order was passed, and the ex parte assessment order also was not served on the writ petitioner. The learned tribunal directed the respondent before it to furnish a copy of the assessment order and issued direction to the writ petitioner to file a statutory appeal. Aggrieved by such order, the petitioner has filed the present writ petition. We have heard Mr. Dugar also and Mr. Tanay Chakravarti, learned senior government counsel, appearing for the respondent. On perusal of the assessment order, it is seen that it is an ex parte order. However, part of the ITC claim made by the writ petitioner has been allowed for the relevant year, and the remaining has been rejected on the alleged ground that the seller has denied the sale transaction and due to non-availability of tax invoice and bank statement. As could be seen from the material which was placed before the learned tribunal, the notices were sent to the writ petitioner through email and no physical copies were served. However, the assessing officer records in the assessment order that
the writ petitioner is not in existence at the place of business, and therefore the department sent the notices through email. More or less an identical stand was taken by the GST authorities who cancelled the registration, GST registration of the writ petitioner. This order was challenged by the writ petitioner by filing WPA 507 of 2022, which was disposed of by directing the petitioner to avail the alternate remedy. Against the said order, an intra-court appeal was filed in MAT 80 of 2022, which was allowed by judgment dated 8/3/2022, and the writ petitioner's GST registration certificate was directed to be restored. Mr. Dugar, learned advocate appearing for the writ petitioner, submitted that the registration certificate has been restored and continues to be valid as on date. Therefore, for more or less an identical reason, the state tax officer has passed an ex parte assessment order. In any event, part of the ITC claim has been allowed, and it is not clear as to how the authority was convinced to do so. In any event, I'm sorry. However, with a view to afford one more opportunity to the writ petitioner, we are of the view that the matter should be remanded back to the assessing officer to consider that the claim of ITC which was rejected and the ITC claim which was allowed shall remain intact. Accordingly, the writ petition is allowed. Order passed by the learned tribunal is set aside, and the assessment order dated 24/5/2019 is set aside only to the extent where the ITC amount has been disallowed, and the matter stands remanded to the assessing officer. The assessing officer shall issue notice of hearing. We'll fix a date here itself. Yes. The assessing officer shall afford an opportunity of personal hearing to the petitioner on 19th August 2025, on which date the writ petitioner will be entitled to place written submissions, produce the books of accounts and all details and documents, and after considering all the particulars which are furnished and the submissions made, the assessing officer shall pass fresh order with regard to the ITC claim made by the writ petitioner. The entire exercise shall be completed not later than 12th of September 2020.
One more. Purchase tax has also been levied, my lord.
Since the
ITC and determination of the purchase tax.
Where do you get purchase tax?
My lord, your lordship will find page 50, my lord.
Oh, 87,000.
Yes.
The writ petitioner shall also be entitled to contest the claim of the levy of purchase tax under section 17 of the Act, and they are entitled to make submissions on that aspect as well.
And consequential interest, my lord.
What is set aside so far as the ITC claim which was disallowed, as well as the purchase tax which was levied.
Well, consequential interest also.
That won't come. That's set aside. What else?
But tax recovery proceeding, my lord. My lord, as a consequence, my lord, the tax recovery proceedings shall also be, my lord, set aside.
In the light of the above order, no coercive action shall be initiated against the petitioner for recovery of any demand that might have been issued. Next.
Item number 4.
My lord knows that, my lord, that it's a review application. What I have understood.
We don't know. We are just getting.
My lord. Now, my lord, I appeared in the, my lord, when the main matter, my lord, appeared and it has been disposed of. Then, my lord, it's an independent matter. My lord, I have not been engaged, but since my lord direction was, my lord, I have to appear before your lordship. My lord, I requested my learned friend that at least, my lord, give me a copy. If it is not provided me, neither I.
No. What we'll do is we'll request Mr. Chakravarti to provide copy today.
My lord.
And we pass an order that Mr. Sen will appear for the respondent.
Yes. My lord.
And we'll probably take it up
And let that be, my lord, regularized by the office of the GP. My lord.
Office of the-
my lord, along with the junior.
Office of the
Government payer, GP.
then Mr. Lalmohan Basu.
My lord.
You are the counsel on record. Junior counsel.
Junior counsel.
You are senior counsel. And Mr. Chakravarti is super senior.
No, I have no, because in this case, of state is the why there is a very restrictive question of law involved.
Government Grants Act.
No, another police report. Latest Supreme. What is police report? A correspondence between the advocate and the state police and state advocate can be treated as a police report under Section 193 BNSS. And the latest Supreme Court explained what should contain in the police report. Then without any trial, how could High Court take it as a evidence, a privileged communication between the advocate and his client? So therefore, my lord, the learned single judge based on the police report, it is not a police report.
So far, I recollect what was in the petition.
No, it's a very important question because police.
No, I am not on that.
Because you are relying on the police report.
If any
You are
question
relying on the
raised,
police. This is not a police report. Police report, as per Section 193, either FRT or charge sheet, and there will be a trial.
no, it is not that type of police report.
Probably Mr. Chakravarti is right. Using the word report is a misnomer, probably.
Yes.
It is a written instruction. Normally, this based on this written instruction, this police inaction court.
Yes.
Proceeds.
Usually
Those
every
9
day,
matters are-
hundreds of matters are being
What I
disposed of.
fallen for, my lord, I understood that one. But point is that when
Or we can direct them to file an affidavit. That's it.
that should be because they're still liable then for, because my lord, they need a training also, because
No. Written instruction given is also binding on the authority. If they give written instruction and the court records that, it is as if a stand taken by the concerned respondent. He can't run away.
No, my lord.
And signed by the officer in charge of the
No,
police station.
please. In Lalita Kumari's case, and subsequently Supreme Court held that if the allegation disclosing cognizable offense, registration is a must, mandatory. If there are certain points, the family dispute, economic comment, then 7 days time is given for preliminary inquiry. And that should be reflected in the general diary. When the police came to a conclusion on the merit of the case, then it is not a police report. This is a very important thing, my lord. Police came to a conclusion without knowing or suppressing the fact there is two orders passed by the division bench of this court as well as passed by the commercial court declaring that this event is invalid. So this point has been suppressed. Just to hear. And another thing, what is police report? Section 190 clarifies police report. If they say they made an investigation. If they made an investigation, there can be 154 earlier, 155, now 174, 173. If it is a non-cognizable offense, the permission of the magistrate is required to conduct an inquiry. If it is a cognizable offense, then no permission is required. Then investigation to be continued, and therefore the procedure is there. Report has to be placed before the magistrate. So when I am terming it, it's not correct. The nomenclature is a police report.
All right. We have heard Mr. Chakravarti, learned advocate, appearing for the applicant, review applicant. In MAT 240 of 2025, Mr. Amal Kumar Sen, learned additional government pleader, appeared for the state along with Mr. Lalmohan Basu. In order to ensure continuity in the matter, we have directed Mr. Amal Kumar Sen and Mr. Lal Mohan Basu to appear for the state in this review application, and their appearance shall be regularized by the Office of the Learned Government Pleader. Now, the learned advocate on record for the review applicant shall serve one set of papers along with all annexures on the learned additional government pleader, so as to enable him to get appropriate instructions and appear in the matter. List the matter on 11th August and the same position.
Well, they should file an affidavit on the point because
let him come, we will deal.
I'm just
You give it as early as possible.
Well,
By
today
tomorrow, today or tomorrow.
Get full marks. Get.
Item number 5.
I beg to appear on behalf of the writ petitioner appellant.
Well, in this matter, I am appearing on behalf of the
Pursuant of
contempt.
last order, my lord's order, a communication letter was issued in the name of Regent order by the chairman of the municipality.
Well, I am handling
Admittedly, there was violation of the statute without following the provision as in the statute. Such sanction was granted by the municipal authorities at that time by the erstwhile chairman of the municipality.
The last page of the order, that is the page 5.
Present chairman, Miller. You'll also kindly have a look to order. First paragraph, Miller. The building of Pundachandra Das was approved by the BOC meeting of the Agra municipality dated 31st August 2018. Without signature of the concerned engineer of municipality, the building plan certificate was duly signed by the then chairman. So admittedly, that was violation of the statute and order passed by your lordship, in the year 2018. That has been passed earlier, but compliance report has been submitted, sent by this way. What I am submitting before your lordship, let there be direction upon the present and ex-chairman.
No, this contempt has been filed for violation of which order?
Yes. Your lordship kindly have a look to the
page, which
order passed by the Honorable Division Bench. Page 39, your lordship kindly have a look. Page 39 is the order passed by the municipality.
Oh, that order becomes.
Arindam Mukherjee is here. No, it has to go before a division bench consisting of Justice Arindam Mukherjee and some other judge, because he is there. Justice Vishwanath Somedar was the acting Chief Justice.
My lord,
along with him, Justice Arindam Mukherjee.
My lord.
If suppose both the judges are elevated or transferred, then it can come before the regular bench having determination. Because
your lordship already took up the matter for 2 times. This is 3rd time.
We thought it was our order.
My lord, your lordship's order was there.
No.
No, my lord, original order was passed by your lordship, but last time and before
last
that,
time it is not an adjudication order. Liberty it is granted to advocate to serve papers, that's all.
As your lordship.
This contempt application has been filed. This
My
contempt application has been filed alleging disobedience of the order and direction issued in MAT 903 of 2018 dated 28/1/2019. Since one of the honorable judges who were party to the honorable division bench is available at the High Court at Calcutta, let the papers be placed before the Chief Justice for appropriate orders to be listed before the appropriate honorable division bench. This stands released. Whatever appropriate order.
But no assignment is required, my lord. No assignment is required, my lord.
Yes. Bench has to be constituted.
As your lordship,
I'll do it.
My lord, that report, my lord,
by tomorrow.
My lord, this report should be kept in the record.
To take it. You give madam a copy?
Yes, I have already sent.
You take that.
Thank you.
Next.
Item number 6.
Well, I am for the applicant.
Lordship, on the previous occasion, your lordship said asked us to produce instruction. Lordship, this is, we have raised a preliminary issue regarding this application for contempt. Because Lordship, he had, firstly, he had never raised any demand before the authorities, no letter. And secondly, a contempt application was filed and also an application for clarification of the order was filed. Lordship,
My lord, because the respondents called the petitioner in his office and verbally told that had you been retired, then only go, others will not go. We're not going to right, you could do it now. Then my lord, if I had clarification for the or not, and then continue, my lord. They compared us.
So it's all in the same day.
In case he is retired, then the service benefits will.
Everything has been granted, Lordship. We've produced.
He's not retired, my lord, he's in service.
He's still in service.
He's in service, they are not giving
all the consequential
back wages, they are not giving my. Can you see your lordship last order? They says no work, no pay. Can you see your lordship last order?
Never. No. Okay. Get the copy. I know. No. Lordship, we have given everything. Promotion of পেয়েছে They also got his promotion.
But you see page 3 of the order, everything has been given.
No, my lord. Kindly see their report. Last August I saw, my lord. The report dated 17 June 2025.
What you see, sir?
My lord, they have written no work, no pay basis, pay back.
He has said today's go through.
No work.
MACP scheme অনুযায়ী তো ইমপ্লিমেন্ট হয়েছে
Page 3 is sufficient.
Back wages not given, my lord. There is order of back wages.
Pardon?
Back wages, my lord.
This letter you received just now.
My lord.
How do you say?
My lord, I've seen 3 relevant portions. No back wages. Only increments that has been given.
Page 3, what is your reply? You get instruction from your client, sir.
My lord, I am daily getting instruction. Back wages not paid. These are the notional benefits has been paid, not the back wages.
Then you file an affidavit.
No, kindly your lordship's order, kindly last order.
You file an affidavit.
No, my lord, kindly see your lordship last order. Then I will.
No
Kindly.
means we will release it. If you want, you file an affidavit. The learned advocate appearing for the respondent / alleged contemptor has produced a written instruction by the senior commandant CAS of unit SMPA Calcutta dated 24/7/2025. The copy of the same has been handed over to the learned advocate for the applicant. But he is granted to the applicant to file an affidavit in case, according to the no. If the applicant is of the view that the order and direction issued in the appeal has not been complied with.
My lord, kindly keep the contempt ready, my lord.
Lordship, the contempt is being disposed of?
No.
It's being Lordship.
File an affidavit.
Lordship.
My lord.
2 weeks.
My lord.
2 or 3 weeks.
2 weeks I'll file.
Thanks.
Item number 7.
My lord, I appear for the my lord, the alleged contempt of my lord, learned district judge.
Your lordship's passed an order.
I submitted a report
Page
on the previous occasion. Lordship, it is taken on record.
At page 153, your lordship's passed an order. Now, my lord, it appears, my lord, that there was a direction of my lords to the observations which was given by my lords in the order, it seems, my lord, that an approach was taken, my lord, in order to non-suit my rights. Just kindly see this order. I need not say anything. I made a representation pursuant to my lord's directions. That the representation is at page 25 This is dated 2/4/2025.
That is after the disposal of the appeal.
Yes, yes. Now, your lordship's directed.
You sought for regularization of the.
I'm grateful to my, and Millard, the observations of Millard's Millard, I have no words to express.
All right. Now,
But-
what did the district judge say?
Yes, yes, kindly see the order.
The last occasion, Millard,
I say, Millard, I very respectfully submit that Millard kindly see the order of the learned district judge. Millard, which your lordships will be pleased.
that was handed, this is 4th of June 2025.
Yes.
Now,
Now, Millard, kindly come to from the third paragraph of the order.
may I place it or?
আমি করে দিচ্ছি। I faced a bus accident. I faced an accident on 12/9/2007. I was not allowed to join from 10th of March 2008. I wanted to join on 10th of March 2008. I was not informed anything till date that I cannot be permitted to join. And just in my very respectful submission, subject to correction of my lord.
No, the learned district judge has rejected, saying that there is no provision.
Provision in the, yes.
Why don't you challenge this order?
Yes.
Miller, I say, Miller, kindly consider one thing. I say, what your lordship is indicating. Miller, I will be retiring on 12th of January 2026.
He's got long. No?
12th of.
Challenge it.
Yes.
And probably an early date can be fixed. See, under which rule, suppose a person enters service, he is entitled to in a year so many number of days of casualty, then so many number of leave on loss of pay, etc. Study leave, there are separate rules. So if you compute all that, what is the permissible leave? You adjust the permissible leave with the leave away. The remaining will be treated
And it will be, Miller, leave without pay.
Leave on loss of pay.
Leave without pay. Therefore, I say even Miller, if it would have been invoked, this man would have been in a better position. I do not bargain anything. What has gone has gone. I cannot, Miller, bring back the past. But at least some sort of Miller sympathies, because I say, Miller, with the greatest of my respect, I repeat.
The direction has been issued.
Lordship.
Dismissing the appeal, granting
Liberty, Millard.
submit a representation to the district judge disciplinary authority for appropriate orders regarding the period of unauthorized absence.
That's right.
So he says that I do not find any provision which authorizes the head of office.
Adjust the unauthorized leave of almost 18 years commencing from 14.
Yes, it's a period of time. Every employee under the service condition is entitled to
Various kinds of leave, including extraordinary leave.
So whatever is admissible, you adjust.
Right, I
Whatever
say,
is not admissible,
deduct it.
salary will be deducted.
Yes, I'm grateful
But,
to my lords.
But here, Millard, Lordship kindly sees.
Take an opinion, your opinion, before you pass this on.
Millard, this.
What is your stand, Mr. Banerjee?
Milord, I am representing High Court administration. Milord, I have seen the order. Milord, my lord's desire was that, Milord, it should be taken into consideration. Milord, a holistic order, Milord.
Yes, yes.
So we can do one thing. We will set aside this and send it back. Let him apply the rules.
And thereafter do it. I do not say
But
anything.
Milord, this was beyond the scope of the original writ petition. That was, Milord, my lord's view also. So, Milord, setting it aside, Milord, in this appeal may not be, Milord, subject to, of course, correction by your lordships.
But that fellow suffered.
Milord, a formal challenge is to be thrown. Milord, he could wait for 18 years. He waited for 18 years. Milord, today he cannot show urgency. He waited for 18 years.
He should challenge in a fresh.
Let him challenge.
12th of.
That will be better. That will complicate the issues more.
Millard, I say, Millard,
Once again, the learned writ court has to send it back. If it finds this last paragraph is
yes.
true.
According to the district judge, Paschim Medinipur has no authority within the ambit of the law to allow the representation made by Tapun Bhattacharya. Hence, the president is considered rejected.
Then some consequential direction should follow after that, which is not here, but still.
Technically, this will be beyond the jurisdiction of a contempt court.
Yes, that's it.
But there are certain decisions which say
Careful to my lord, consequential directions can also be passed in contempt.
no, contempt jurisdiction is curated.
Yes. I'm grateful to my lords.
Yes,
That is also permissible. But he is an employee of the court. What was he employed as?
Miller, he was a bench clerk.
And he met with an accident.
Miller, he met an accident, a severe accident.
Now, how is his health condition?
He can walk.
Is the question.
Unauthorized means illegal informal.
My lords will kindly also have a look at paragraph 8 of my lord's order.
If
Miller,
your
if
lordship
today
Miller
Miller
directs me, I
directions-
can ask him to be present in the court on the next day.
No.
Milord, if today Milord a direction is passed setting aside Milord the order passed by the learned district judge, Milord possibly that will militate against Milord paragraph 8. Might, Milord, this is my humble understanding.
That is why we say,
Yes.
as on date, the period of unauthorized absence having not been regularized, question of granting relief in favor of the appellant in this appeal would not arise.
More so in the
Also
writ
in the
petition.
Yes.
Single bench being conscious of this fact did not foreclose the remedies. It gave him liberty.
That could have.
And
Lord,
paragraph
if I have
5,
given Miller-
paragraph 6 also.
ডিস্ট্রিক্ট জায়গায় দুটো লাইন লিখে দিলে ওটো ভালো ছিল
আর ইনকামের উপর সে চলে গেছে
Whether the district judge is still continuing or new person has joined.
Malad, this is the new. I think Malad, this district judge. I think is still there. Malad, Lordship had decided the matter on merit, but Lordship wanted pragmatic view that if he makes it, that should be considered.
Even assuming without a court direction, they are required to apply the rule and adjust, even in case of unauthorized absence. Assuming he had retired from service now, how will you compute his pensionary benefits or retirement benefits? So what to be done with this 18 years? Either you should adjust it against admissible leave, treat the remaining as leave on loss of pay, then compute his length of service.
Or break in service, it may be even break in service.
Break in service, you may even deny him pension, saying that you did not have 10 years of
I
continuous
get your Lordship's mind. I get your Lordship's mind. But here, Malad, this Malad, on merit, Malad, the appeal was dismissed.
Appeal dismissed. Because the single judge granted that liberty, we modified that slightly and issued direction.
Yes.
And Miller, the observations.
Sir, one thing, sir, if we send it back also, he can also say that the period cannot be regularized because it is extraordinarily beyond permissible limits and therefore should be treated as break in service.
That may also happen. I know.
Your Lordship may kindly consider that so far as my.
What we can do is, we'll keep this on Monday. You discuss with your client. Many times, your friend also.
I'll speak to the.
You please interact with the registrar inspection. Inspection 1, I think. Paschim Medinipur, Subrata Polle, Mr. Polle. We won't say anything today. We just adjourn it to Monday. we'll, because that exercise needs to be done, any event. Either you reject his claim in toto or you adjust whatever is admissible leave. 18 years can't be adjusted,
No, 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 I do not say that.
but it may result in break-up service.
That's what I said. No, that's what I said.
Actually, district judges may not be good in this. It is only the administrative staff they will be good. They only prepare the pension papers. Because I have signed my pension papers. I know.
They may be.
I said I don't want any registrar. Whoever is the person who's dealing with that section. So 3 people came.
Well, kindly do not embarrass me, Miller. These are I must not make any comment with
No,
regard to this.
not like that I'm saying. So they are well versed. This time, original side, we have got almost 19 retirements. 19 people are retired. Severe dearth of staff. So he came and said, then he wanted me to exercise option for commutation of pension. I said, I don't know what to do. Then the one lady, the madam came, then she said, you do this means what will you get, what is the pension you will get. Right, option 2, what is the amount on hand, what is the pension, then what? Then I asked her, what do you suggest? Then she said, you choose option 2. I chose option. They are very new. In fact, leadership knows more about all this. But
Basically, department are mainly supporting all the department person. They are the
Yes, yes.
List the matter on Monday under the same caption.
Yes. That's a great.
Item number 8.
My lord, I appear for the appellate, my lord, along with Mr. Idunil Nondi and Mr. Sheikh Konar. My lord, this is a matter in which your lordship was pleased to hear on an earlier occasion pertaining to an appeal against the judgment and order dated 25th of August 2023, passed by the learned single judge, wherein the learned single judge came to a conclusion that the writ petition was not maintainable on the ground that the prayers made in the writ petition ought to have gone before the district judge, who was the appellate authority under the statute. Am I audible to your lordships?
Yes. Now, who is the appellant before us?
Appellant is before your lordship is the. We are the appellant.
We are the lessee of the leasehold land.
We are the original owners of the leasehold land.
Lessee.
And my lord, our land was acquired for a particular period under the Act for a period of 60 days. But my lord, ultimately what happened was, for 60 days we were paid off our dues, which was agreed upon by us and the department. But instead thereof, they held over the land for another 2 years and odd, for which we applied for additional compensation for the extended period of time at the old rate, which was granted by the competent authority, exercising its powers under Section 10(1) of the Act. And that was pursuant to an order passed by this Honorable Court in a petition filed by my client before our lordships, before the learned single judge, wherein the learned single judge is pleased to direct the competent authority to take into consideration all these issues and pass a final order. At that point of time, the learned advocate appearing on behalf of the respondents did not, my lord, come up with the argument that the petition was not maintainable. It was only after the order was passed by the learned competent authority, granting us additional compensation over and above the initial period of 60 days, for which we had already been given compensation, that the state, that the respondents came before your lordship and argued that this petition was not maintainable, because this additional compensation amounted to modification of the initial order passed by the competent authority, which could only have been done by the district judge in accordance with section 10(2) of the Act. Now, the Act is, my lord,
Yes.
My landlord junior will hand over your lordships copies of the the Act, my lord, before your lordships, my lord. The petroleum and mineral supply acquisition of rights of user of the land, 1962.
Now, in the first round, where is the order passed in the first round of the litigation?
Page 134.
Page
134. Volume 1, page 134. Volume 1, paper 134.
132.
134. 134.
134. Yes. So the direction was issued to the authority to consider your representation for enhanced compensation.
Enhanced compensation, no, my lord, may I be bit, my lord, may I only say, my lord, the question of enhanced compensation and additional compensation may have a different connotation. My lord, there may be a difference between the two words, because my learned friends on the reading on the other side, they may be taking this defense that whether it's an additional compensation or it's an enhanced compensation. If one is agreed by the initial computation of the compensation by the competent authority, according to them, then any changes in the computation will amount to an enhanced compensation, or someone being agreed will have to go before the district judge. But in our case, your lordship sees the initial panchnama for which the land was taken by the authorities concerned was 9.08 acres for a period of 60 days, which was then calculated by the competent authority at the rate of rupees 450 rupees per decimal, amounting to rupees 42 lakhs and odd. That was paid to us. Now, when the authorities concerned were unable to go ahead with the entire job, and rather they sat over the matter and ultimately handed over the land over to me. After additionally taking over possession of the land for more than 2 years, we applied for additional compensation. And Manoj, that was permitted by us in terms of section 10(2). If your lordship,
What is the language used in the Petroleum Act?
yes, your lordship sees, kindly sees page section 10(2) first. 10(1) and 10(2). If your lordship kindly sees the word compensation.
This is page 163.
I may not got a copy of the thing at page 163 of the book, my lord. And then your lordship goes to section 10(2), appeal before the discharge. If anyone is aggrieved by,
If the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of compensation shall, on application by either of parties to the district judge, within
in
the
our case, we had
jurisdiction of the
accepted
land
the
dispute, be determined by that district judge.
yes. So, but in our case, this case does not arise because for the initial period of 60 days for which we were granted compensation, we accepted that. Neither the respondent be agreed by the computation made by the competent authority, neither did we.
Sir, before the authority, competent authority, or before the competent authority, IOCL has filed a written statement objecting to his jurisdiction. So the learned single bench, without going into the merits of the matter, directed consideration of your representation.
Yes.
Obviously, it means consideration in accordance with law.
No.
When the matter is taken up by the competent authority, IOCL says you do not have jurisdiction.
That's it.
See, the competent authority, upon determination of this compensation and effecting payment also in your case 42 lakhs, he becomes functus officio. That direction which you took in the earlier writ petition is a futile direction. It is not going to help you at all. You should have filed a petition before the district judge saying that compensation is inadequate. So, if an authority, the competent authority has got no jurisdiction to redetermine the compensation under subsection 1 of section 10. If he fixes X as the amount, you want X plus 1 and he wants X minus 1. Both need to go to the district judge.
With respect, may I submit before your lordship's honor, the initial compensation, let us assume that it was X. No one is agreed by that amount. The initial compensation was for a fixed period of time for which the right of user was sought to be taken over by the authorities concerned. It is for the additional period which they consumed and they took over possession for which they are not paid as any compensation.
No, that they have denied before
No,
the
they cannot. I'll show you, lordship. But on facts, they are absolutely. They are only on the issue whether additional compensation for a period which is not determined by the competent authority on the earlier occasion, whether that amount has to be gone for the district judge, or whether that would be heard and decided by the competent authority. In my humble submission, the competent authority, having not decided the additional compensation for the period which was subsequent to the initial period, in my humble submission would be that he would be the competent authority to decide only that issue. And if their IFC was aggrieved by the...
No, sir, please show us your claim petition.
Yes, I'll show your lordship. Before your lordship takes up, I'll show your lordship the original Panchnama.
Sir, Mr. Kundu, please stay away from the mic a little bit.
Very,
If you
very
too
good.
close to the mic, it's echoing.
May I do one thing for your lordship? May I do one thing? Since there is a divergence in so far as talking is concerned, may I come before your lordship tomorrow in court in person and argue the matter in front of you? So that
If it suits you, well and good. In the meantime, if you can ask your junior,
lordships,
prepare some dates and events.
I have prepared a list of dates which has been handed over to your lordships. If your lordship has not been served with the
And in the dates and events, you should indicate the page numbers also.
Yes,
of the
yes,
stay
yes.
petition. So, and you make a brief summary of facts. See, if we have understood your case,
lordships,
your claim for compensation is not for additional compensation or for enhanced compensation.
No.
But it is for compensation in respect of the lands utilized for which no compensation was
Yes,
paid.
I'm deeply obliged. I'm deeply obliged.
That is your case.
That is only my case.
So you have to, you are very, very simple, sir. Your copy of the earlier writ petition.
Yes.
I think IOCL did not file any affidavit in opposition in the earlier writ.
No.
No.
No, they filed. No, they filed.
Yes,
I'm
yes,
sorry.
we did file.
You have filed.
Before Justice Bhattacharya, yes.
You any affidavit in reply?
Yes.
Yes. So you may ask your junior to make a convenience set. Earlier writ petition, affidavit, affidavit in opposition, reply.
We'll file.
I believe all these.
No, Mr. Kundu.
Mr. Ghosh is here.
What is their name?
Shormishta Ghosh.
Jobishta.
Shormishta Ghosh.
Shorbishta. Okay.
Shormishta, my lord.
Shorbishta Ghosh will do the preparation. See, you prepare a convenience set. It's all too bulky. You heard Mr. Kundu's submission. That is very, very simple. He says this compensation is a claim for the first instance. It is not additional. It is not enhanced. This is in respect of land which was utilized for which no compensation was paid by IOC. That is long and short of his case. So what you do is, whatever is relevant for them, one should contain dates and events. It should be absolutely neutral, not your side or his side, containing.
We'll send a copy to them.
Yes, we have to give them. You give them a soft copy, they can. In that, what you do is, first copy of the representation, then no action taken, writ petition filed, writ petition, affidavit in opposition, reply. Justice Bhattacharya's order. Then you will before the competent authority. Their claim before the competent authority.
Yes.
Your written submissions, objections before the competent authority. Order passed by the competent authority, if any. Then writ petition filed by the second Bhattacharya, Justice, before him. Affidavit in opposition,
there was
nothing. Second writ petition, copy of the writ petition, and copy of the Justice Bhattacharya's, Sabhishashi Bhattacharya's. This all is required.
Your Lordship will prepare a convenience set or only the list of events and dates?
The list of events and dates separate, convenience set separate. That list of date and events should also contain the page number of the convenience set.
Yes, but the paper book that they have filed, Your Lordship, this contains that. I can say I'll make a convenience set, Your Lordship, but this has that exactly in that order. Your Lordship, what fell from your
Which one?
The papers, the pleadings here. The stay petition.
The stay petition
incorporates all apart from the writ petition will not carry to your Lordship's court previous.
No, we
first
don't.
writ petition.
First writ petition pleadings are not.
So we don't want this gazette notification. That all not required. That let it remain. In case Mr. Kundu or Mr. Busru Bhattacharya wants to refer that, we will go to this. Otherwise, make it a small set of 50 to 70 pages.
Very good.
Once again, you put
one thing is will be difficult. In the event the pleadings in the previous writ petition are annexed, then it becomes again bulkier. What I suggest to your Lordship is, we'll carry the writ petition separately. What I was telling her before it fell from my lords, first is an index containing
Justice Bhattacharya's order is the trigger here. After Justice Bhattacharya's order, my lord, the matter travelled to the competent authority. Whatever the minutes of the competent authority and the pleadings filed before the competent authority, ultimately, my lord, Justice, the order under appeal.
Only 4
Only 4 or 5 documents would suffice. That would not bring it to 50
before
pages.
the competent authority
Yes,
is required.
Yes, minutes before the competent authority.
Writ petition copies are here. We can.
We will. Very well. We'll prepare
And
it.
your writ petition was allowed, saying that they have to go to the district judge.
Yes.
And under the Act, it will be treated as a proceedings of arbitration, is it?
My lord,
No, my lord, there is
not
no.
arbitration, my lord.
No,
The
no, no.
competent authority is, my lord, empowered by law to decide the quantum of compensation. In the event someone is aggrieved thereby, my lord, irrespective, my lord, the honorable single judge in the matter under appeal, in one of the paragraphs record that, my lord, what exactly fell from my lord the honorable the Chief Justice, that even if we have said that the competent authority is to decide, he has a right to say that and right to decide his own jurisdiction also.
The earlier writ petition did not go into the merits of
Yes.
it. So therefore, he has to decide in accordance with law.
With law presupposes, my lord, his own jurisdiction as well.
But CPC applies.
Yes, for laying evidence.
The competent authority to have the powers of the civil court.
Like, I think that certain section 30 of the
Yes.
Land Reform Act.
Land
Acquisition Act. Land Acquisition Act. There the compensation
trying a suit,
taking evidence.
Exactly.
In that even the lordships, the matter may be taken up on the next date with your lordships.
How much time you would require?
We'll come on Monday.
Monday. All right.
Yes, Monday, but we'll circulate it to Mr. Kundu's instructing advocate, by Saturday.
Soft copy.
By Saturday, soft
By
copy.
if it is possible for Mr. Bhattacharya to send it by email, by soft copy by Friday.
For the Mr. Kundu, everything is possible.
It will not be elevated to such a exalted position.
We have heard so and so. In order to facilitate the hearing of the appeal, not only for the court but also the learned advocate for the parties, we suggested that a convenience set be prepared containing minimum documents that would be necessary for considering and disposing of this appeal. Miss Sharmishta Ghosh.
Sharmishta, my lord, I believe.
Sharmishta Ghosh, learned advocate, appearing for the respondent, Indian Oil Corporation, has readily agreed to prepare the convenience set and also convenience set with an index and also dates and events with the relevant page numbers in the stay petition. What Ghosh, you do one thing. In these dates and events, give the page numbers of the stay petition, annexures and stay. Stay petition. Let a soft copy of the same be furnished to the learned advocate on record for the appellant as a soft copy, preferably by Friday. What is Friday's date?
31st.
First of August. List the matter on 4th August.
4th August. 4th is monthly list. We have 4th August.
4th, no.
4th.
5th August. 5th August.
Make it.
Great.
Can it be on 6th, my lord?
6th August.
6th August.
My lord, at 2 p.m., my lord.
Pardon, sir?
My lord, at 2 p.m., 6 on the 6th.
If Suddenly it may be 10:30 also.
We'll
কোটা
take the chance. We'll take the chance.
রাজি ফাজি হয়ে যেও না এই স্যাটারডে কিন্তু রাজি হয় না স্যাটারডে জজ সাহেব কোর্ট করবে 2 তারিখ
We'll have it on 2nd.
নো নো নো
I have no problem. I'll be there, Your Lordships. It'll be easier for me to
This book from the library. Yes, please. Next.
leave no pledge.
Item number 9.
Lord, this matter, my Lord the Chief Justice and my Lord Mrs. Hirodma Bhattacharjee have been pleased to hear substantively
yes.
that Aadhaar regulations constitutional validity.
Where is Juma's? Madam
I'm
Juma's?
led by Miss Sen.
Where is she?
She's not in court today.
She's in Delhi, is it?
Oh my lord, she's running a fever, so she.
Oh.
If your lordship share it, then it has to be started anew. Because we raised a preliminary objection to the
No,
maintenance.
it has to go before the other division bench. Because our notes itself, we have taken about 10-12 pages notes.
And it is at reply stage.
Oh.
They had given the reply, we were supposed to give the reply.
Since this matter was extensively heard by the division bench consisting of the Chief Justice and Honorable Justice Hiranmai Bhattacharjee, it is but appropriate that the matter is listed before the said division bench. Accordingly, this matter stands released from the list of this court to be listed before the for appropriate orders of the Chief Justice.
May not kindly give us some time because I am told that Mr. Lokhi Gupta, who was appearing for the UDI, is seriously ill.
Seriously?
So possibly he will not be able to appear in this matter at all.
My goodness.
He had some problem in the tongue and there is bleeding, excessive bleeding from the tongue and all this. So my learned friend will have to engage another lawyer.
He is in the hospital, is it?
No, he's coming, but what he said that he won't be able to attend court anymore. It is so serious.
I didn't know about it.
So come, sir, kindly.
Then you have to make some alternate
Your
arrangement.
Lordship, we were at reply stage. We'll make an alternative.
No, reply means Juma will not leave at that. She will start from point A.
But it has been recorded that she has concluded her submission.
She will not agree.
No, I had spoken to her. She had said that I have finished my reply.
She might have told you, but she will not agree. It's a compliment for your senior. Go and tell her. She'll feel better today. She won't. She'll say, I'll give a small recap. That's how she'll
Yes,
start.
that will happen.
Kindly see 5th September order.
We have recorded so.
Yes.
Sir, assignment order says before first DB. DB1. DB1 is this DB no?
No, my lord, the Chief Justice has taken exhaustive note, I understand.
Yes.
So recapitulation is not necessary at all. And if it is required, then we shall also have to recapitulate.
Let us see.
Kindly keep it up.
But then, Amrita, you make some alternate arrangements. You talk to senior and because if that person has to reply, that senior counsel has to reply, he should know what was submitted.
Your Lordship, we have already prepared a notes in consultation with my learned senior, Lokhi Gupta.
Yeah.
So we will get ready. The new senior as well will get ready.
So let the papers be placed.
Your Lordship is fixing the matter.
No, how we can fix a date? It has to
whenever
come to me on the administrative side. Then we have to constitute that bench.
Your Lordship.
No, I'm for the respondent assist demand.
State of West Bengal.
Yes, our appeal, but we do not have the papers. Mr. Mukherjee has.
He will give you the papers. What is this matter?
We don't have Mr.
No,
Mukherjee.
we claim the refund before the sales tax department for the period 2007-8. Refund was granted. Then, my lord, they did not refunded the amount of rupees 12,56,000. Then we made an application before the West Bengal Taxation Tribunal under Section 8 of the West Bengal Taxation Tribunal Act. The tribunal has granted the refund, directed the department, Commercial Tax Department to refund the amount within 3 months.
It is echoing today, Disha. Why it's echoing?
Kindly take this matter next week. We'll come back. Raniro.
Sir, একটা copy.
Now you're contesting this 12 lakh claim.
I don't know anything.
No, it's a refund claim.
Yes, sir.
Partly you have allowed.
Allowed,
and
that I
paid.
saw.
The remaining about 12 lakhs and 64,9,477 was not paid. The tribunal found that export of goods has been admitted, or rather not in dispute. He has produced details and documents to also establish that the respective vendors or sellers have filed returns. That's also not there. Now, asking him to produce documents after 20 years, this is the claim for the year
7-8, my lord.
7-8 was unreasonable and directed to do it. And what are your grounds? What is the best ground you have raised? But do you have also a litigation policy, no?
Yes, ma'am.
State also has got a litigation policy.
This is of 2012.
But the policy which is in vogue, when the matter is being heard, will apply.
Absolutely, extend her. Give me a 1 day's time. If I feel malad, I'll talk to the department. Department did not have first. Difficulty is Mr. Mukherjee is no more with us. But unfortunately, he is no more with the on record. So malad, we could not get hold of the documents.
There are 38 dealers who are involved, who are local registered persons. T. Chong Tannery, University, SL Zippers, etc. Please come to page 13 of the writ petition, para 8. This is the reasoning of the tribunal. Para 8, 1, 2, 3, 4.
Yes, I saw
But
that.
how he will produce 38 people of the year 2007-8? We are in 2025. Even if we think we have to send it back, nothing will happen.
Can you give me must be not of such importance. 2012 it is pending. No one has taken step. Can you give me a week time? Taking over.
Sir.
Okay. Let them give me a copy, my lord.
You give that to today itself.
Actually, we do not have another copy.
You have marked.
We will provide today, my lord. We will provide the copy.
As if it's all big secret. You are marking.
No. I will provide the copy of the petition along with the reply. My lord, will share with my learned friend.
Mr. Tanay Chakravarti appears for the appellant for the state of West Bengal, the writ petitioner. We have heard Mr. Avram Asmundar, so and so, the respondent. Let a copy of the writ petition along with annexures be served on the learned advocate appearing for the writ petitioner, state, by the learned advocate appearing for the respondent within 2 days. List the matter.
Grateful.
You give a date, sir.
Grateful, my lord.
Grateful.
That's all. For which matter Mr. Maynard Bose is waiting? For which matter Mr. Bose is waiting? There is no next matter. Monthly list. Let it remain in the month. So we will call it a date. That's it. TAV file original side is sent on